good afternoon, at least for those of you who are attending this webinar in Tokyo or in Japan and the rest of East Asia. This is Takeo HOSHI, a former deputy director of the Tokyo College, but now the director of the Tokyo College starting a couple of weeks ago. Many of you have attended Tokyo College events before, including the webinars by distinguished visiting professors. So many of you may know what Tokyo College is, but I think it's worth reminding you what we are trying to build here at the Tokyo College. And it's perhaps more important for me to remind myself the purpose of Tokyo College as I start my lectures. So here we go. Okay. Tokyo College was created within the University of Tokyo in February of 2019. So that's 5 years ago, with the purpose of generating new knowledge to contribute to the creation of an inclusive society and sparking deeper public engagement. The Tokyo College slogan is shaping a shared future together. And we have been doing this job. We have been a central place for interaction between the University of Tokyo and other research institutions, research and education institutions, both domestic and overseas, and also the society in general. We have been inviting several distinguished scholars from various parts of the world and having them give seminars. And our invited speakers, I want to stress, are not only distinguished researchers and experts, but also sympathetic to the main goals of Tokyo College. They are open to interdisciplinary discussion and serious about public engagement. They often challenge the common sense, as it will happen today, in the efforts of creating new knowledge, but also they always respect scientific views that are not necessarily the same as their own. So we together try to create new knowledge through open and respectful discussion to make contribution toward more inclusive society. So that's what the Tokyo College wants to do. And today's speaker is a good example of a distinguished scholar who fits the purpose of Tokyo College. Professor Frank Upham is Wilf Family Professor Emeritus of Property Law at New York University Law School. He's known for his research on law and society from comparative perspectives, and he has very deep knowledge and relations with many countries in Asia, including China, Vietnam, Cambodia, Laos, and of course, Japan, or especially Japan, where he has been visiting many times. He speaks Japanese as well as Chinese, in addition to English and French, of course, and German as well. I remember you were learning German at some point. Right. And he has been visiting Japan, as I said, periodically for the last half a century. His first book on Japanese law was Law and Social Change in Post-War Japan, published in 1987, and received Thomas J. Wilson Prize from Harvard University Press. He has visited the University of Tokyo many times in the past, but I am really glad that he's a visitor at our own Tokyo College now. Today, his talk is titled, Why the Destruction of Property Rights is Necessary. The talk is partly based on his book, published from Cambridge University in 2018, with the title, The Great Property Fallacy. So the book with a provocative title, and today's talk challenge the common sense, at least among simple-minded economists like me, that protection of property rights is always good and essential for economic growth. So I really look forward to the talk and discussion. And to lead the discussion today, we have an excellent commentator. Professor Masaki NAKABAYASHI is a professor of economic history here at the University of Tokyo, and is an expert on institutional economics and Japanese economic history. So I can say he's an ideal person to comment on Professor UPHAM's talk today. Now, I will ask Professor UPHAM to talk for about 40 to 45 minutes. And that will be followed by Professor NAKABAYASHI's comment for about 10 to 15 minutes. For the audience of the webinar, you can write in your questions using the Q&A function of the Zoom, and you can do this during the talk. And I will be watching Q&A on my Zoom application on my PC and select some of them to share after the talk and also the discussion. Okay, so let's start. Professor UPHAM, the floor is yours.
Thank you very much, Professor Hoshi, and thank you and Professor NAKABAYASHI and Tokyo College for this opportunity. I am honored and also flattered that you have asked me to give this talk, and I believe deeply in the central mission of Tokyo College. And in the short time I have been here, I have felt that shaping a shared future together is indeed something that is happening here. As Professor Hoshi said, this talk is somewhat controversial, although in the world of today's politics, talking about property rights is not going to be all that controversial with all the things that are going on now. But within the world of law and somewhat the world of economics, and particularly in the world of development, my central thesis that you must destroy property rights to have rapid economic growth is, I think, goes against the conventional wisdom. And so in order to put that idea in context, I would like to start with 4 qualifications, which I have called a prologue, things which I am not saying. And that's the kind of cautious approach that at least American lawyers, and I think Japanese lawyers as well, usually take when they're trying to introduce something somewhat new. So the first point is, I'm discussing rapid economic growth. I'm not discussing 2% a year, 3% a year. I'm not discussing the kind of economic growth that Japan or the United States or France can expect and hope for. The focus is on developing countries, not rich ones. So it's on property rights in, we always say developing countries, and I will use that phrase, but I think it's important to keep in mind that many developing countries are in fact not developing. They're just poor, but we don't use the word poor, we use developing countries, and I will use that as well. So those countries, Bangladesh, Uganda, and many of the other 200 plus countries in the world, they don't need 2% growth. They need 8% growth. They need 14% growth. They need rapid economic growth. The third point in my prologue is that I'm not addressing political issues or moral or justice issues. I say I'm not addressing them, but I actually will comment on them, because what produces economic growth, particularly rapid economic growth, is not always just. There are losers, and there are people who don't deserve to lose. So I'm not going to discuss that as a central issue. The fourth, but I would love to discuss it in the conversation afterwards. The fourth point that I want to make is that I'm talking about the destruction of property rights through political and legal processes. Property rights are also, perhaps much more frequently, destroyed by technological issues. So, to give an example, Professor Hoshi mentioned a book that I published in 1987 and one that I published in 2018. In 1987, I made money from that book, not a lot. It was not turned into a movie. But I got royalties. The 2018 book, forget about it. No royalties. The whole idea of copyright has been destroyed by the digital revolution. If I want to watch a movie now, I actually do it legally, but most people want to watch a movie, they just go online and they pirate it. And that's why Taylor Swift is going on a worldwide tour, because that's the way she makes money now. She doesn't make it from records. When Elvis Presley was the equivalent of Taylor Swift, he didn't go on big tours. He just sat there and got money from his record sales. So those are the 4 qualifications. And now I will try to talk to explain the idea that I have qualified. And that is that for rapid economic growth, you've got to destroy social structures. You've got to destroy economic structures. And the legal, to a certain extent, political structure that supports existing societies are property rights. So this idea came to me gradually. I have taught property. It's a basic American law course at New York University School of Law and at other American law schools for over 30 years. And as I taught that subject, I didn't start out as a property expert. I started out as a comparative law expert, specifically China and particularly Japan. But as I taught property in American law schools, the American law schools use what's called the case method. So you learn the rules by reading different judicial cases, one after another, after another, after another. And as I taught those property cases, I realized that each case was about changing property rights. You didn't read a case, or I didn't assign a case and then teach a case that said what already existed. It was always a change. Well, when you change property rights, you're destroying them. So I like automobiles. If you came to me and said, oh, you see your automobile over there, Mr. Upham? We're going to change the property right to Professor Hoshi. That's not changing my property right, it's destroying it. And as I taught property law, I realized that the first case in my property course was in the 18th century, 1763 or something like that, all the way up to the 22nd century, whatever century this is, 21st century. Okay? Each case changed a property right. Each case destroyed a property right. And slowly, as I was teaching, I came to realize that social change, if not social progress, because every social change is not progress. But I think in general, society is better than it was 300 years ago. And each one of those changes was really, in the property area, a case of the destruction of a property ownership. The second factor that made me become interested in this topic was watching China. As Professor HOSHI mentioned, I also have some experience in China and also some experience in Taiwan. And I have watched the growth of the Chinese economy with great interest and have done some research in the area. China, over the last 30 or 40 years, has brought more people out of desperate poverty than any other society in the history of the world. Some 800,000 or 800, a lot of people. And they did it without any property rights whatsoever. In the other examples that I have talked about so far and we'll talk about, at least there's some written property right. At least my car belonged to me and I could have a little piece of paper to show it before it was taken away and given to Professor HOSHI. But in the Chinese experience, there were no written property rights. It wasn't until 2006 that they even passed a law. And passing a law does not change much unless that law is enforced. And that law it's a broad statement, but the law has not been largely or fully enforced. So China grew from the end of the Mao period when Deng Xiaoping came in to the 21st century without property rights. The third example or the third factor that made me want to write this book and then give me the opportunity to give this talk to a very exciting context was a trip that the World Bank asked me to take to the Lao People's Democratic Republic. The Lao PDR, People's Democratic Republic, wanted money from the World Bank. And the World Bank is like most institutions and like most people. If you want money from them, they want you to do something. And what the World Bank invariably asks countries to do is to get good, solid property rights. Okay? And that's the conventional wisdom that I am attacking. For various reasons, which I would be happy to talk about later, the World Bank asked me to go to Laos. I was not their first choice by a long shot, but nobody else would go. I went, I studied, I did some empirical research. I found, did not surprise me, that Laotian growth was occurring illegally. It was occurring in areas of highways where it was illegal, according to the Lao PDR statutes, to have this growth. My reaction was, this is good. It's good to have growth. Doesn't matter if it's informal or it does matter. I'm sorry, it does matter, but it's a hell of a lot better to have growth that's questionable legally and questionable politically and maybe even questionable morally than to have no growth at all. So let me now turn to the outline of my argument. And I give I list 5 examples of this kind of destruction of property rights in order to create rapid economic growth. The first one is one that's extremely well known in the small world of Anglo-American common law. England, US, Australia, so on, Nigeria. And that is the enclosure movement, starting in the 13th century and going all the way up to the 19th century. It took a lot longer than the other examples that I'm going to give. And it was called the enclosures. And before the enclosure movement, villagers had a right to go into land owned by the Lord of the manor. And they could go, and that land was known as the commons. And you could go in there and collect wood, fuel, or wood to build something with. You could go in there to hunt, to fish. That property right to enter the Lord's commons, however, meant that the Lord could not use that land as he wanted. There was a limitation. The limitation was the property right of villagers to go in. The Lord wanted to enclose that land and pasture sheep. And that explains the reaction in the 19th century of Sir Thomas More, who, the end of that process, which was done by law, it was not necessarily done legally in the sense of being faithful to legal principles. But none of these examples are faithful to legal principles in that sense. But it wasn't done by killing the villagers. It wasn't done by hiring the army. It was done by changing the legal rules, by changing property, which was the destruction of the commoners' rights to go in and get things. So Sir Thomas More summarized this process with the following quote: "Your sheep," that is the Lord's sheep who now are in the commons, "that commonly are so meek and so little, now, as I hear, they have become so greedy and fierce that they devour men themselves." Now, of course, those of you who know sheep know that they don't eat meat. So they're not actually devouring the commoners, the villagers. They're devouring their property. And in doing so, they're destroying it. The second example, which I will come back to later, is 19th century US water law. 19th century US water law, the case that I use to demonstrate the destruction of property in this instance, is called the Sanderson case. And I will come back to it in a few minutes. But basically what it did was, it took away the rights of farmers to have clean water, to have good agriculture. At least at this time in 19th century America, you needed clean water and a fair amount of clean water. And what happened was, when industrialization started in the US, they needed coal, the industry. Coal polluted water. So there was this conflict between agrarian interests, the farmers, and industrial interests, the coal companies. And through a very, very interesting legal process, the coal companies won, and the farmers' property rights were destroyed. The third one I've already mentioned, and that was 20th century China. And I'll come back a little bit to that one as well. The fourth one is Japan. And I talk about two aspects, or two times, when Japan changed, i.e. destroyed property rights. One was the Meiji Restoration, which of course that's another euphemism. It wasn't restoration, but anyway, when Meiji Japan needed to respond to the Western imperialism that was infringing in East Asia, one of the things they wanted to do was introduce a Western legal system. Japan had a legal system. That's one of the myths that Americans like to think about, is that Japan did not have a legal system. Of course it did. It was just one that American Westerners couldn't understand. And if they couldn't understand it, they assumed it didn't exist. It did. But the Meiji government had felt it had to transform, and I think they did have to do so, their legal system into one that looked like a Western legal system. To do so, they had to individualize, formally individualize land rights. And in doing so, it's an extremely complicated process. They destroyed a lot of land rights because it was hard to do this on a national scale, as we will see with Cambodia as well. So that was the first instance of the destruction of property rights in Japan. The second was 200 years later, no, 100 years. It was, I guess, 100 years later, after World War II. And here, it's hard, this is a complicated subject, but the Allied occupation of Japan after World War II was dominated by the United States. And American government officials under the Roosevelt and then Truman administration, and a fair number of Japanese politicians felt that one of the causes of the militarization of Japan, which was, of course, a democracy in the Taisho period, much, much earlier than much of Europe, even though Europeans like to think of themselves as having a more democratic tradition than Japan. It's simply not true. But Taisho democracy failed. Part of that was because of rural unrest. Part of that was blamed on landlords. I don't know whether that's true, but that was the perception. So land reform. And the landlords in the Showa period after World War II lost their land in an extensive land reform that gave landlords land to their tenants. And it transformed a group of farmers who were tenants on another person's land into being their own private property owners. And that was done with the goal of strengthening democracy in Japan. And I think it succeeded. Now, I think many people living in Tokyo think that farmers have too much power in the democratic process in Japan. That's an issue which I'd love to talk about over a beer maybe, but not today. What did happen though was the creation of a very fundamentally solid democratic state in Japan. Okay. The last example is Cambodia. And I think I will hold that for a moment and come back to it at the end. So the second part of my argument is to talk about the role of law. Because as I've said, in none of these cases was it a dictatorship coming in with the army and taking property from one person and giving it to the other. The transfer of property from one person to another, the destruction of the pre-existing property ownership in land, and the creation of ownership in land, a new property right in the second person, was done through legal processes. And that's important because it legitimizes it. If it's done simply by brutal force, it's not legitimate. It's not politically legitimate. It's not legally legitimate. And it's not morally legitimate. So that is the role of law. The role of law was to legitimize the destruction of one person's property right and the creation of the property right of another person. It was to do, and I have two economists here, so I'm a little nervous about this. It was to do what something called the Coase theorem says will happen with wealth in capitalist societies, societies that allow bargaining, that allow one property owner to sell her property to another. But Ronald Coase, and that was the name of the University of Chicago, very famous economist, very powerful in American legal law schools and law schools, and people talking about law and economics and how law interacts with economics and with the market. What Coase said was that in order to have growth, or in order to create wealth, the people who own property should, but cannot use it that productively, should transfer that property to someone who can use it more productively. Now, that transfer is ideally in the imaginary world of law and economics, done through sale. So if a farmer owns land and can make, let's say, $100 a year off of farming, but a railroad could use that land and make $500 a year from using it. The railroad, by the way, would be, quote, using the land, perhaps by going through it, but also perhaps by putting out sparks and burning it. But either way, the railroad needs to own it. The ideal way would be for the farmer to sell it to the railroad for somewhere between $101 and $500. That transfer takes place, and wow, wonderful. We have a productive railroad and we have a satisfied farmer. It never happens. It only happens if you make 5 assumptions about the way markets work. And these 5 assumptions were listed by Ronald Coase's colleague, Harold Demsetz, also at the University of Chicago. And Professor Demsetz writes about these 5 assumptions, and Professor Demsetz and Ronald Coase says these assumptions are never true. They're not always true. Not that only some of them are true, but that not a single one of them is ever true. And just to give you an example of what one of the assumptions would be, it would be that protecting property rights was costless. Of course, that's not true. But in order to make the Coase theorem work, they have to be true. So you assume they're true. Now, economists know those are assumptions that are not true. But when that comes into the legal world, most law professors are not economists. Some of them are, not most. They don't know economics. They just heard about the Coase theorem. So what law does is it, in the name of the Coase theorem, transfers property from one person to another, from the farmer to the railroad. If the farmer doesn't want to sell, law figures out a way to make him sell. And we will come to that in the case of Sanderson. So the second point is, I guess, is what I've already really said, which is that the role of law in rapid economic growth in poor countries, where rapid economic growth is incredibly important, okay, is to legitimize the destruction of property rights, to legitimize the transfer, the involuntary transfer from one less productive party to another more productive party. Okay. And by doing that, by that transfer, what is created is a new system of property rights that will be more productive than the old system. So, and that's what I've experienced with copyright. The pre-existing copyright system, that protected music, fiction, literature, and so on, has been destroyed by digital revolution. And the law has let it happen. All right, let me give you two case studies. The first one is the coal case, which was the 19th century water law. And this gives you a detailed explanation of how it happened in one place at one time. And therefore, it doesn't prove anything, but is an illustration of how this productive destruction of property rights can work. Mrs. Sanderson was a farmer in Pennsylvania. She had fish ponds and she had agriculture. To maintain her life, she needed clean water and she needed a certain amount of it. And that was fine. She had a complete property right to that, called the right to the natural flow of water. But as industry started, a company called the Pennsylvania Coal Company, which still exists and is still a huge company, Penn Coal, started to mine coal upstream from Mrs. Sanderson's farm. They dug a hole, and unfortunately for Mrs. Sanderson, when you dig a hole, water comes into it. The coal company then, of course, pumped the water out, put it into the same stream that Mrs. Sanderson used. But when they pumped it out, it was deeply polluted. And when it reached Mrs. Sanderson's farm, it killed all the fish. And I don't know whether it destroyed, but it diminished her agricultural output. So Mrs. Sanderson, being an American and knowing that Americans are litigious and love to sue, sued the Pennsylvania Coal Company. And she was confident she would win because she had a clear property right to the natural flow of water. And she did win the first time. It went up to the Pennsylvania State Supreme Court, and she won. Then, however, the lawyer for the Pennsylvania Coal Company ran a political campaign to become a justice of the Pennsylvania Supreme Court. One of the things that most people don't realize about American courts, and many Americans don't realize, is that most judges in most states, not the federal system, are elected. They're elected as being for Trump or being for Biden. They're not elected, they all say they're elected for the rule of law, but they're either Republicans or they're Democrats. So the lawyer for the Pennsylvania Coal Company ran to be on the Pennsylvania Supreme Court the next election. He won. And when he took his seat on the Pennsylvania Supreme Court, he changed the decision. So, and I'm not, this I don't remember exactly the votes, but let's say it went from being 4 votes in favor of Mrs. Sanderson, 3 votes in favor of Pennsylvania Coal Company, to being 3 votes for Mrs. Sanderson, 4 votes for Pennsylvania Coal Company, and the natural flow doctrine of water was destroyed. Her property right in that water was destroyed. As a result, we had industrialization in Pennsylvania. Was that a good thing? Well, I like televisions, I like cars, I like flying, I tend to think it was a good thing. I've never worked in a farm. I understand it's very hard. I would rather be a law professor. So I guess I'm going to say it was a good thing. The second example is contemporary Cambodia. As I said, the Khmer Rouge, who took over Cambodia after the United States invaded during the Vietnam War, destroyed all laws, most educated people, all lawyers, overthrew Sihanouk, turned Cambodia into a wasteland. When they were overthrown, not by the United States, but by the Vietnamese government, and Cambodia became again open to rational development, the World Bank and other international organizations and national states like the United States wanted to help. And well, they should. It's great. And following the conventional wisdom, they told the Cambodian government, you need to have clear property rights for land. And so, using satellites and lots of other really wonderful things, they plotted, doing the same thing that the Meiji government did, but using much, I don't know, better, but at least fancier technology. And the farmers, who even during the Khmer Rouge had been farming land, had been going into mountains and so on, okay, were given formal deeds to the land that they had been using. Now, these farmers were ignorant. And what I mean by ignorant is the fundamental meaning of that term. They didn't know anything about law. They were largely illiterate, just as I know nothing about farming and don't know how to play any musical instrument. I'm ignorant in those fields. They're ignorant in law. But they knew they'd gotten this right. And then people from Phnom Penh and from outside of Cambodia went to the fertile areas of Cambodia, went to the farmers and said, we'll give you some money for your land. How much money? Well, not much to the international corporations, and I don't mean to blame them necessarily, but not much for them, but a lot to the farmers. So the farmers signed the documents, which they, of course, didn't understand. What was the result? Well, as the World Bank and the IMF have documented, Cambodia has been growing very fast. And they've grown fast through various sectors: textiles, tourism, and agriculture. The agriculture has been in large-scale production of sugar, which has been exported, I know, to Europe and perhaps also to Japan, Taiwan, China. And it has been large-scale production of sugar has been made possible because the entrepreneurs coming from Phnom Penh or from Taiwan or from Brussels bought legally bought the land from the farmers, consolidated the land, and started to produce sugar. What happened to the farmers? I don't know. Some of them undoubtedly became day laborers on farms, one of the lowest social statuses in the world. Some of them went to Thailand, perhaps, to work in construction or the service industry. I don't know what happened to them, but they didn't get rich because their property had been taken. Their property rights had been destroyed. Their property rights had been transferred from them to the large corporations. So what is the message that I get from these examples? One is that in order for the rapid growth that is occurring in Cambodia now, that occurred in 19th century US, that occurred in China after the reforms, requires structural changes in society. Those structural changes are often in the forms of property rights. How do they change those property rights? Well, if you make the 5 assumptions of Harold Demsetz of the University of Chicago, if you make those assumptions, you can just do it, or it'll happen automatically. But those assumptions are never true. So that has to happen somehow. Now, if all the farmers or book writers or whatever just say, oh, sure, take it, then, and there's a market that allows them to do that, wonderful. But that never exists. That structural change has to happen somehow. And the way that that has to happen is to destroy property rights. And the important message is to do that fairly, justly, and politically legitimately. So in that sense, I will end and say that a shared future together, which Tokyo College is aspiring for, is a future where the losers in the property transformations can get some meaningful place in that shared future. So thank you very much.
Yes, thank you, Professor UPHAM. And the discussant or the commentator is Professor NAKABAYASHI. So the floor is yours. Go ahead.
Yes, thank you for the fascinating lecture. Inspired by Frank's talk plan, I reflected when property rights were felt in early modern and modern Japan. Let me summarize the reflection quickly. First, about property rights, usually in economics, property rights are defined like this. Property rights consist of residual claim and residual control rights. They are rights of shareholders. So it's a kind of important of shareholders' rights to a kind of, legal concept or concept applicable to other issues. But usually economics stick to this definition. And then the idea is like this: with the claimant would exert with the control rights to maximize on surplus, which is residual, she or he earns, and that would lead to improvement in resource allocation. Like landowners would optimize land use and shareholders would optimize internal physical and human resources allocation. And this is almost that reason economists appreciate property rights. Actually, this incentive scheme inevitably imposes additional risk on residual claimant. Residual claimant must take on either upward and downward risks. And this is related to, according to my guess when they fail and work. In the first about early modern, it's a previous step. Professor Pam mentioned 17th century. So in the 17th century, the Chauvet and laws in advanced domains implemented cadastral surveys. And the principle and overview were like this. So the Chauvet or load specified every single parcel of farmland. And by the Japanese agricultural techniques, unit was very small, and unit was and is very small. But they specified very small parcel of farmland and specified a stem family. Stem family means grandfather, father, and son. So no extended family, stem family, and that cultivated parcel. And then the Shogun vested that stem family with property rights over the parcel or the family cultivated, and in return, imposed land tax on the family. And then, since that, Japanese archipelago has been covered by numerous smallholding owner farmers. So this is the origin of very fractured land ownership distribution of Japan. Okay, then what happened? We cannot identify statistical causality, but at least the accompanying outcome was continuous rise in agricultural productivity, and because of that, per capita GDP rose like this. This is Japan. This is Japan's per capita GDP, and this is China's per capita GDP. So in the Kamakura Shogun period or a Heian period, our per capita GDP was just half China's. But however, in the 18th century, finally, Japan's per capita GDP surpassed China's very first time in its history. And also, this one is Poland. Also, Japan's per capita GDP caught up with peripheral European nations in early modern times. This outcome is consistent with economists' prediction. Property rights would accelerate growth. And seems like it did happen in early modern Japan. However, yes, property rights did work in early modern Japan, but conditional on very heavy regulations on farmland and farmland collateral loan markets to prevent owner farmers from raising leverage too much. Otherwise, they would have lost their properties. And also, the Shogunate established a risk-sharing scheme between the state and taxpayers, such that land tax was automatically reduced in case of poor harvest. Exact number was 30%. So if output was dropped more than 30%, land tax automatically reduced. So the risk was actually shared between the state and the landowners. And and furthermore, this is exactly related to Frank's talk. Actually, this standard institution was not necessarily implemented anywhere in Japan. Actually, there were exceptions in backward regions, and a big one was Kaga domain. The lord who used this campus as official residence and embassy in Edo. So Lord of Kaga did not implement cadastral surveys, and instead left village level joint ownership since medieval times remain. Okay? So why? The reason is very straightforward. In the Kaga domain, productivity was substantially lower than in advanced domains or the Shogunate domain. And then, as I emphasized, vesting property rights inevitably imposing additional risk. Then, given the productivity of the Kaga domain, exclusive property rights of individual household would have been too much. And so, Lord of Kaga avoided implementation of cadastral surveys and establishment of property rights in a kind of modern sense. Instead, maintained medieval joint ownership, village level joint ownership. So to put property rights to work, maybe the state should regulate property owners to prevent them from taking excessive risk as in the sovereign domain and advanced domains, or otherwise, if the risk, if the subject's risk, people's risk tolerance was too low, the state should not introduce exclusive property rights and let joint ownership remain. And this was a practical decision-making in early modern Japan. But this drastically changed after the Meiji Restoration of 1868. So in 1873, two drastic reforms were implemented. One was land market deregulation, and also the other one was land tax reform implemented by the imperial government. And for instance, exclusive property rights were enforced across Japan, including backward regions like Kaga domain, Ishikawa prefecture, Wakaushi prefecture, that did not adopt exclusive property rights. But now the very same property rights law was implemented. And furthermore, farmland markets and farmland collateral markets were completely deregulated. And then now farmers were allowed to borrow as much as they liked by pledging their farmland. And also, the government denied land tax reduction in post-harvest. So the risk was exclusively taken on by farmers. Then the outcome was very straightforward. The great collapse of owner-farmer class. Tenanted land ratio sharply rose. So it's a little tiny, but these numbers are changes in nationwide average. So tenanted land ratio was just 27% as of 1873 when the reform began, but it sharply rose to 45% around the 1900s. So almost half of arable land came to be owned by landlords. Then, so what? The problem is it delivered a very complicated system. So typical contractual scheme of landlordism in Japan was like this. First, rent was fixed. However, as Shogun offered, or Lord offered, in a poor harvest, rent reduction was automatically offered first. And then, based on relational contracts, tenant farmers, actually, who were ex-owners of the land, were still rigid claimants. So once performing payment of fixed rent, surplus rigidly belonged to tenant farmers. So landlords share the risk with farmers at the only modern state had them. And under this informal risk sharing scheme, still cultivators, tenant farmers remained rigid claimants. Then, what kind of lessons we can deduct from these experiences? So if property rights are enforced beyond assumed property owners' risk tolerance, informal relational contracts like landlordism after the Meiji Restoration would arise as a scheme of risk sharing shall and it means that, yeah, so this is exactly what he the word he used. The Meiji government extended formalization of land ownership, but extended formalization of property rights by the Meiji Restoration actually evoked landlordism as an informal risk sharing mechanism. Property rights may work if the risk to which property owners are exposed is within property owners' risk tolerance. Then to realize such aim, very fine-tuned regulations and risk bearing by the state may be necessary, as we saw in only modern Japan, but otherwise an informal risk sharing mechanism might come into existence, which means formalization of a property system ironically delivers further extended informalization, informal sector. This is what I thought inspired by his work. That's all for me. Thanks.
Okay, so thank you, Professor Nakabayashi. So at this point, I'd like to share some Q&A. Let me see, from the audience. But before I do that, let me clarify, because I'm a bit confused how Professor UPHAM's lecture and Professor Nakabayashi's comment are related. And since I'm an economist, and I think I understand the property rights and economic growth a little bit better than the average audience. So if I'm confused, I think that many other people in the audience are confused. So let me ask a question. So I think the Professor Nakabayashi's comment is basically saying giving property rights to a certain class of people increased the economic growth in Japan. But in order to take advantage of that benefit of the property rights to a new group, they had to come up with, or Japan had to come up with some new form of risk sharing, because increased property rights or the giving property rights or having property rights increased the risk to some owners of the properties. Okay. Now, I thought Professor UPHAM's point was the property rights, giving property rights to new type of people who can increase the economic growth, at the same time destroying the property rights of property rights of people who enjoyed property rights in the past. So in your example, there was a joint ownership, I guess, of a land before the reform or the changes in Edo period. And so that was not, well, that was a giving property rights. That what happened was a giving property rights to the landlord, but at the same time that took away some property rights.
That's right.
From the old people. So in that sense, the property rights was destroyed.
Yes.
And the destruction of the property rights was important.
Yeah.
So
in that sense,
do you agree with Professor?
Yeah. So this is related to one big issue I skipped actually. So when property rights were established in the 17th century, yes, someone lost, and the losers were armed leading farmers in villages. So usually medieval farmers were armed, and they managed village community, and they were engaged in negotiation with feudal lord. And in return, they assumed a big chunk of claim. Then cadastral surveys implemented by the shogunate and laws were in effect destruction of claims of such people. And that's why against, actually, there were many revolts, many riots against cadastral surveys. And such riots were usually mainly led by leading armed farmers who had a big chunk of claim within their villages. So, Shogunate and laws first destroyed vested interests of leading armed farmers and protected new ordinary commoners. This is what the Shogunate did, basically.
Okay.
So
shall
more
we
productive.
go on to a Q&A from the audience, or do you want to
Well,
respond to
This
Professor Nakabayashi?
is fascinating. So one of the lessons that I would take from what you just said, Professor Nakabayashi, is that reorganization took place in the 17th century,
Yes.
not so much in the 19th century.
Right. It began in the late 16th century and completed in the late 17th century.
And these armed farmers, swords, bows, I mean, what kind of arms did they have?
Swords, basically.
Okay.
Yeah.
And so one of the things that happened during this process, in the consolidation of the Tokugawa shogunate, was the destruction or the centralization of the government. You didn't have lots of villagers which were militarily independent.
Right. Yeah, actually,
Fascinating.
they still they owned many farmers owned swords, but using swords to resolve conflicts was banned.
Of course, there are a lot of things which are banned, but the only other comment I would make to Professor Nakabayashi's discussion is in the reduction of rent in bad times. One of the things that I have always admired in Japan, and although first time I came to Japan was a long time ago, it was in the 20th century, not the 17th century, but has been the bureaucracy. And what I take now from your discussion of risk sharing, which requires the government, which is a bureaucracy, to reduce those taxes, is that there was an effective, honest bureaucracy. And in the United States, the word bureaucracy is, in Japanese terms, kind of waruguchi. It's a bad, but bureaucracies are bad. I think, in my study of Japan, that one of the reasons that Japan has become such a successful society is that it has had more than any other country I know, and of course, I don't know what the bureaucracy in Bulgaria is, but Japan has one of the best bureaucracies in the world. And you're saying that this has been true for hundreds of years.
Okay, shall we move on to questions from audience?
Yeah.
Okay, before we
Maybe from
get into the details.
From some bureaucrats, maybe.
Maybe, I don't know the first person, but this question is from one of the audience. Shall I read the name of the questioner? No, we shouldn't do that? Okay, so even though the questioner showed his.
I actually wanted to appear without my name.
Okay, maybe next time. So one of the questions say, Professor UPHAM mentioned that property right prevents growth. However, I think example Professor mentioned shows that property rights is important. However, property right needs to shift based on the change in economic condition. It is ideal if change in property rights happens by voluntary transactions, but because 5 conditions on cost theorem are not met, some change in property right rule is necessary for us to grow. This doesn't mean property rights is not important. It's important, but some democratic intervention is necessary. What do you say? That's a question.
I think a distinction has to be made between guarantees of return on investment and effective property rights. So effective property rights can be one way to guarantee that an investor or a farmer who's investing time and labor will get a return. When we think of property rights in countries like the US or Japan or France, or a return on investment, when we think in terms of property rights, the right of a shareholder in a corporation to get, or the shareholders as a body to get dividends, and so that and they have a property right to those dividends that they can enforce against the corporate management. But property rights are just one form of guaranteeing a return on investment. And in many instances, such as in 20th and early 21st century China, there is investment both by domestic investors inside China and by foreign investors using other forms of guarantees for investment rights. And those would be working through the Communist Party on a local level or at a national level, most significantly at a local level, because China actually, although it's changed somewhat under Xi Jinping, my understanding is China was actually very much against at least the American stereotype of China, was very localized. And different counties and different villages and different xian would control their own economy much more than we think. And that those investment rights by foreign companies coming in, like Apple, would be guaranteed not by reference to formal property rights, because they didn't exist, but by negotiations with those local governments. So I absolutely agree that investors need return. And it's not just investors, farmers need return. I'm just saying that in order to get growth, you sometimes have to betray, you sometimes have to destroy that expectation and give it to somebody else. And that can be done by the local governments in China, changing the commune structure, or it can be done by legislation in the American state, such as Pennsylvania. So I think what American law professors and World Bank policymakers is they collapse guarantees on investment into one form, which is formal property rights. And I think that's too narrow.
Okay, thank you. I think the next question from the audience, and I think that this one, we can share the name of the questioner. This is from Masayuki Tamaruya.
I've never heard of it.
He asked, if property rights should be destroyed, the next question seems to be, what property rights should replace them? Do you have any view as to how they should look like?
I think, yes. I have a normative view, and I can express that normative view in more instrumental language. The normative view is that when the property rights of the average small farmer in Cambodia And I think in most of the literature, they're discussed as, quote, peasants. I don't use peasants because Americans, Westerners never use peasants to refer to Europeans or Americans. They only use peasants to refer to Cambodians or Africans or something. But those small farmers, for it to be stable, have to have, or to be just, have to be given some adequate compensation. It doesn't have to be property rights. It doesn't have to be the reduction in rent. It could be the shift of ownership to a big plantation. But when that plantation is created through entrepreneurs coming from Phnom Penh, maybe the farmers should get shareholders' rights. And it's not going to be shareholders' rights like the Wall Street Journal in rural Cambodia, but it would be something done through local bureaucracies, local governments. So it's called a meaningful compensation that can survive political contests, which is extremely difficult in a rich, sophisticated country like the US, and it's even more difficult in a poor country.
Okay, thank you very much. So, well, you started talking about a little bit about the more advanced countries, which you said you stay away in this talk. But the next question from this anonymous audience is a related question. This says, I know this concept mainly applies to developing countries, but if you were to try to articulate this into matured countries like modern Japan, do you think I guess the argument works just like how it had been? If not, what are the issues we need to take into consideration in mature economy, away from a developing context, I guess, development context?
In a mature economy with a democratic government, Japan, the US, France, I mean, I just mentioned France because it's another place I've studied a little bit. It's much more difficult to do this effectively and fairly. And I think that's one of the messages of the digital revolution. A long time ago, 20 years ago or something like that, I remember an article in the Boston Globe which said that a Boston University student was arrested for illegally downloading music from the internet. And why that made a headline in the Boston Globe was not because there had been theft of a property right. I was teaching a property class at that time with 100 students. Every one of those students had illegally stolen music from the internet. I had not. Why? Because I didn't know how yet. But once I learned, of course I did. In fact, I plan to, in another presentation, steal the rights of the singer, American singer Tina Turner, in a presentation. Now maybe Tina Turner's executors will find. So I don't have a good answer to this question. It's a very, very good question. And the question is, how do you deal with these fundamental changes, in this case, brought about by technology, that destroy whole markets, whole industries? And I can see that happening perhaps to the automobile industry over the next 20, 25 years. And I think what has to happen is there has to be some kind of compensation. There has to be some way for a democratic structure to create avenues for the losers to not lose too much. If you don't, I think what you end up having is what happened in the United States after the last presidential election, and there was an invasion of the US Capitol. And I'm simplifying it, very complex. But the people who led that movement are people whose ways of life, being an automobile worker, being a labor union member in an industry that was destroyed by free trade, by trade with China, they lost their sense of value. So what has to happen is that loss has to be compensated for in some way, or it has to be made more gradual. And it's not just money, because a automobile worker in the United States, which 40 years ago was a great job, might even be able to make the same amount of money by becoming a security guard. But the social context of being an automobile worker was one that made that person feel that they were a full human being respected by society. Whereas a security guard is not. And I don't have any answers to that. And
Okay, I think this next question is a related question. That says, property rights cover a very broad range of property, and right to play music, or the copyright to a music or song is, I guess, one example. Right to own a land is another one, or to enjoy the product from a land. So this question says, property rights covers a very broad range of property. Is there a study or research that shows what type of the property right is good for the economic growth? And what is barrier to the growth? So is there some studies which says that destroying this property right is good, or protecting this property rights is good, but not this one, or something like that?
Well, I think there certainly are studies about what sectors should be protected and not protected. To use the example would be in the Chinese communes under the Mao regime, agriculture, local governments in China were put into communes. And in the productivity of those communes was very low. Then Deng Xiaoping came, liberated those, dissolved those communes, and went back to individual agriculture. Most of those people benefited tremendously. But some of the weaker members of that society lost, because they depended on being in the commune. They were weak. They needed the common wealth of that commune to survive. When the communes were dissolved, they lost, and there's a literature in contemporary China called reform literature, the literature about people who lost when China became capitalist. And so I think if you ask what kinds of property rights have to be protected, I'm not going to talk about agricultural rights versus music rights. It's the kinds of property rights on which people depend for their fundamental existence. Those have to be either protected or effectively compensating. And effectively compensating is very hard. And I say this seriously. If you have a bureaucracy like the Japanese bureaucracy, you might be able to do it. But the American bureaucracy in all the states is often not good enough. So what you have to do is back off from doing everything quickly. Do it slowly, especially if you're in a rich country. You can afford it. if you're in a poor country, maybe you can't afford it. And maybe just like those people in Chinese communes, they lost.
Okay, these, I see many questions keep coming.
Really?
This is not the first time I moderate for the Tokyo College discussion, but I think, well, we seem to have a more active audience today than usual. So I think your talk went very well. There are actually a couple of questions about carbon pricing.
Carbon pricing.
The questioners argue that the carbon pricing is, in a way, is a destruction of property rights of coal power plants or the people who operate coal plants or fossil fuel plants or those plants that emit a lot of carbons. Take away the property rights for them to produce carbons. So I guess so the question is, what's your thoughts on carbon pricing? Do you agree?
I think that's yeah, I agree.
Okay.
And I think one of the reasons why President Biden is not just saying we're going to do away with coal-fired power plants is because the threat of climate change, which says we should do away with coal. If you do it too quickly, he will lose the next election. And so he's not going to do it. And he gets criticized by environmentalists correctly. But that kind, yes, so I agree. Carbon pricing is the destruction of property rights. And the only thing I can say is maybe you do it slowly, but fast enough so that we're not all underwater. I mean, literally underwater.
Okay, good. So your answer is definitely yes.
Yes.
Masaki, do you want to add or?
Yeah, I agree.
Yes,
Okay.
let's make Masaki answer.
Okay, so the questions keep coming, but we are running out of time. So I think we have to end here. And so sorry, I didn't give Masaki to answer the questions very much in the Q&A session, but we need to close. So I want to thank Professor UPHAM and Professor Nakabayashi again for excellent talk and excellent discussion. And I'd like to thank the audiences, a very active audience today for sending in lots of questions. So this ends the webinar today. And do we have the survey form or something? We usually see, okay. So we don't show the survey form today, and we just end the webinar here.
So we won't get a grade.
Yes, or we may ask the audience to respond later. But this is the end of the webinar today, and thank you very much. Thank you very much, speakers and the commentator. And thank you very much, audience, to listen to this talk for 90 minutes.